Every employee deserves the right of due process, and it is safe to say that no two claims are the same. Therefore, whenever a situation occurs where there are facts yet to be discovered, a workplace investigation must be conducted. Whether it is an investigation of harassment, a wage and hour claim, an accident, or a supervisor abuse claim, workplace issues can take an incalculable toll on its victims, their families, the workplace, and coworkers. Only through an investigation where the HR manager, the DLSE, the EDD, the CRD, an attorney, or a private investigator gathers the facts can a determination be made. Internal investigations include a broad spectrum of reasons for a need to investigate, and there are no cut and dry ways to resolve all cases. Regardless of the nature of the investigation, the steps that should be taken when conducting an investigation are generally similar. These should include a prompt initial response to the complaint, including notice requirements if applicable, meeting with complainant, alleged harasser if applicable, and potential witnesses, gathering additional information that may be beneficial, such as payroll records, video, audio recordings, correspondences, and personnel files, and compiling a report of the investigation to include determination, potential corrective actions necessary, and follow-up expectations. When conducting an internal investigation, any W-2 employee who has access to the necessary information contained in the complaint can assist in conducting the investigation. However, when hiring an outside individual to assist with the investigation, there are clear restrictions on who an employer can turn to. A practicing attorney who normally performs this type of work can be retained to conduct the investigation, as can a licensed private investigator or, with a few restrictions, an off-duty currently sworn peace officer. HR consultants that perform investigations without a private investigator's license in California would be performing these activities illegally. However, an organization can hire an HR consultant to assist with the investigation, but not conduct it wholly. When considering terminating an employee, there must be a great deal of thought and process put into it. It cannot be a shoot-from-the-hip type of emotional decision. California law provides comprehensive workplace protections for employees, some of which govern how, when, and under what circumstances an employee may be legally terminated. Many employees believe that they cannot be terminated from employment unless they break a company rule, have performance problems, or break a law of some kind. But that is not necessarily true. Most employees in California are considered to be at-will employees, unless there is a contract as mentioned earlier. At-will employment means that the employee is free to leave their job at any time, and employers are likewise free to terminate the employee at any time for any lawful reason or no reason at all. An employer can terminate an employee because they just don't like them. But the question becomes, why didn't they like them? Is it possible that the reason they didn't like them has something to do with their unconscious bias? The risk associated with terminating at will may actually show that the employer terminated the employee based on one of the following illegal reasons: because of their race, gender, disability, sexual orientation, religion, or other protected characteristic, for their political beliefs or affiliations, because the employee requested time off that they are legally entitled to take, because the employee reported a violation of the law, or for reasons that violate public policy. Now, if there is an employment contract where the employer agrees to hire an employee for a specific period of time, but does not specify the circumstances under which the employment can be terminated, then the employee can only be terminated under 3 circumstances. The employee willfully breaches one of their employment duties, the employee is habitually neglectful of their employment duties, or the employee is unable to perform their employment duties for some reason. Wrongful termination is a situation in which an employee's contract of employment has been terminated by the employee, The termination breaches one or more terms of the contract of employment, or the termination breaches a statute, provision, or rule in employment law. In the case of wrongful termination, an employee may get compensatory damages, punitive damages, or in some cases, reinstatement to their former job. Compensatory damages are a type of monetary award intended to make the employee whole again. This type of damage award can include pay for the employee's missed wages, back pay for unpaid wages, if any, or other compensation for harm the employee experienced as a result of being wrongfully terminated. Employees generally cannot sue their employer for wrongful termination if they voluntarily resign or quit. This creates a perverse incentive for employers who want to fire employees. They can avoid wrongful termination lawsuits if they can somehow get the employees to quit first, usually by making the employee's environment intolerable in one of many ways. To combat this problem, courts in California have adopted the doctrine of constructive discharge. Constructive discharge occurs when the employer's conduct effectively forces an employee to resign. In a mixed motive case, the discriminatory intent must have been a substantial motivating factor in the negative employment action taken against the employee. It is not enough for the employee to merely show that the discrimination was a motivating factor. It must have been a substantial motivating factor. An employee is not required to prove that the discriminatory motivation was the sole motivation behind a negative employment action either. The employee is only required to show that there was a causal connection between the employee's protected status and the action. An employer can reduce its liability if it can show that a legitimate, non-discriminatory motive alone would have led it to make the same decision anyway, regardless of the discrimination. We mentioned some agreements companies may want to utilize earlier in this training, but during termination, some of these agreements can come up again, so it is important to rediscuss these here, along with some new termination agreements as well. A severance agreement is generally used when an employee needs to be terminated, but there is little or no prior documentation of misconduct or performance problems. There is no legal requirement under California law that employers provide severance pay to an employee upon termination of employment. Severance plans provided by an employer pursuant to the Employee Retirement Income Security Act, or ERISA, are subject to federal law. Severance agreements are used to provide departing employees compensation in exchange for the employee's release of potential claims against the employer. As such, they can greatly limit the risk of a lawsuit. For a severance agreement to be enforceable in California, a valid release of claims must be knowing and voluntary. It must be written in simple language so that the employee can understand it. It must provide consideration beyond that to which the employee is already entitled, which it can require remains confidential. And the employee must be provided time to consider the agreement and the right to consult an attorney. As far as what it must not do, as a provision of SB 331, a settlement agreement may not prevent or restrict the employee from disclosing factual information relating to all claims of harassment, discrimination, or retaliation under FEHA. As well, it must not prohibit the employee from disclosing unlawful workplace acts, unless the agreement is part of a settlement for an employment discrimination-related claim and the employee was given notice and opportunity to retain an attorney. The employee must not be required to sign the agreement in order to get full compensation that is rightly owed them. And severance agreements should not include illegal, non-compete, or no solicitation clauses. When an individual signs to release their right to a claim, they are signing to release their rights to claims with which they have known about. Section 1542 of the California Civil Code addresses the rights individuals have to unknown claims that may be later discovered. The code, which states, a general release does not extend to claims that the creditor or releasing party does not know or suspect to exist in his or her favor at the time of executing the release, and that, if known by him or her, would have materially affected his or her settlement with the debtor or released party. Unless a release agreement cites to Section 1542 and states that the employee is waiving unknown claims, employees can retain the right to bring claims they did not know of when signing the release. This provision must appear in any release of claims in California, and there additionally must be language clearly stating that the employee waives this provision and intends to release all claims known or unknown at the time the severance agreement is executed. While the release of claims statement in a severance agreement may contain a covenant not to sue, it may not prohibit the employee from filing a charge of discrimination with the U.S. Equal Employment Opportunity Commission or the California Civil Rights Department. Likewise, the Securities and Exchange Commission takes issue with provisions prohibiting employees from reporting securities law violations to that agency. Therefore, to avoid an attack by one of these agencies on a severance agreement, a provision should contain language stating that the agreement does not prohibit the employee from filing charges with or reporting violations of law to any law enforcement agency, but that the employee waives any monetary recovery from the employer as the result of any such charge or complaint. In addition, in California, releases of workers' compensation claims are not valid unless signed by a workers' compensation judge. A general release of claims, therefore, will not bar an employee from filing a workers' compensation claim, and a release of workers' compensation claims in a severance agreement will be invalid without a workers' compensation judge's approval. We recommend that employers considering using severance agreements hire a labor law attorney to prepare the documents. Historically, when utilizing settlements after the resolution or claims from workplace incidents, employers want to include a refusal to consider for rehire provision. AB 749 created Section 1002.5 of the California Code of Civil Procedure, which prohibits and invalidates all such provisions that can be interpreted to prevent workers from obtaining employment with settling employer or affiliated companies based solely on that fact. Once the decision has been made, the following California required termination notices should be provided. For your benefit pamphlet, this is the same one provided during the hiring process. Notice to employee as to a change in relationship, which should list the particulars related to the current termination. New health insurance marketplace coverage options. There are two notices here, one for employers that do not provide health insurance and one for employers that do provide health insurance, regardless of whether the employee participates in the plan. If the employee was enrolled in a company-sponsored health plan, the appropriate Cal-COBRA or COBRA notice, as well as the HIPAA and HIP notices should be provided. If applicable, 401k and additional plan information should also be provided. California employers must provide at least 60 days notice stating why the change is necessary, and an affidavit signed under penalty of perjury that the contents are true to affected employees under 3 types of events. A mass layoff, which is a layoff that affects 50 or more employees that have been employed for at least 6 months during the last 12 months, and that lasts for 30 days or more. A relocation of the facility of 50 employees or more, moving over 100 miles away from the original location, or a termination or a location closure that results in the cessation or substantial cessation of industrial or commercial operations and affects at least 50 employees. Cal-WARN also requires that notice must be provided to each of the following: the employees of the covered establishment affected by the order, the Employment Development Department, Workforce Services Division, the local Workforce Investment Board, and the chief elected official of each city and county government within which the termination, relocation, or mass layoff occurs. As with many items under California law, there are 4 exceptions to the notification requirements under Cal-WARN, and in these circumstances, the employer may be able to provide less than 60 days notice or no notice at all. The exceptions to Cal-WARN are faltering company, which is available for relocations or terminations only. Employers can avoid the notification requirements if they can prove that they were actively seeking additional capital or to increase their business. Additional capital or business would have kept the facility open. And the employer believes that providing the notification would have prohibited the employer from obtaining the additional capital or business. Number 2, completion of a particular project, available only in specified industries. In the below circumstances where the employees are hired with the knowledge that they are only needed for a particular project. Wage Order 11, broadcasting industry. Wage Order 12, motion picture industry. Wage Order 16, certain on-site occupations in construction, drilling, logging, and mining industries. Number 3, seasonal and temporary employment. Employees must have been hired with the understanding they were seasonal and temporary employees. And 4, because of physical calamity or act of war.